Why was it that Lyndon Johnson pushed so hard for the Voting Rights Act? Northern liberals actually viewed Lyndon Johnson with a great deal of skepticism. I'm asking a big question. Books and books have been written about this, but I'd love to hear your thoughts on that.
Yeah, there were some reasons to be skeptical of him. Obviously, as the Democratic leader in the Senate, he had been responsible for killing some civil rights bills in the 1950s, and so they had some reason to be suspicious. But Johnson himself, often harkened back to his first job teaching at a school full of extremely poor Mexican American kids in South Texas, and just said that once he had power, he wanted to use it on behalf of people like that. And as probably the purest politician the nation has ever produced, at least in the 20th century, he recognized the importance of the vote and just believed in the importance of the vote. And so voting was important to him. I think it's actually easier to explain why Johnson would have pushed as hard as he did for the Voting Rights Act than it is to explain why he pushed for the Civil Rights Act. But he used every bit of political capital he had on this, and he certainly won over those people who'd been suspicious of him in the first place. Never quite satisfied all of the civil rights activists in the street who believed that he could have done more, but that's the nature of politics, right? So that's a short answer. You can spend the rest of your life trying to psychoanalyze Lyndon Johnson, certainly, and as Jeremy mentioned, lots of historians have done it, and there's a big bookshelf full of those biographies that do it. The Robert Caro biographies, I think, are the best in explaining where he's coming from and what he hoped to do. So if you're looking for your own answers, that's where I would personally start.
Great. And now sort of focusing in a little more on the Voting Rights Act itself. And then we have a bunch of questions we're going to get to, some great questions from Nicole and Robert and others. But I just wanted to ask one quick question about and please put up other questions, teachers, too. But before we get to them, Todd, the Voting Rights Act itself, who wrote it? Just give us a little bit of a sense of how a bill like this gets written. Who decides what's in there? Because I'm sure as our discussion evolves, the language is really important.
It's largely written by the Justice Department. It has to work its way around the Senate Judiciary Committee. It has to work its way through the House. Lyndon Johnson used all of the knowledge that he had gained in the Senate. He knew exactly where all the bottlenecks were. He knew exactly who the senators were. He had to make promises to that he could call in for this. The master horse trader and just a master of knowing what motivated other politicians. So the Johnson administration, I think it's generally accepted as does most of the writing of the bill. Johnson himself does a lot of the horse trading that's necessary to get the votes. And we'll get into some of the nitty gritty, but it creates new responsibilities for the Justice Department that had not been there before that I think are really important that we can get into.
Great. Okay, we've got some terrific questions. Rada asks about primary sources in general. I'm going to wait to come back to that one when we talk a little bit more about methodology. It's a great question. I just wanted to acknowledge to Rada that I know it's there. Nicole asks a perfect follow-on question to much of what you just said. You speak of the recent events that target voting rights in states that have passed voter restrictions as attempts to take action regarding voting rights. How do you recommend that teachers make connections to their students?
Well, this is not simply history. This is not simply past events. This is very much an unfolding, ongoing story. I'll go ahead and just put it out there. It's easier for me to talk about that in a college classroom than I know it is for some of you in a high school classroom. So I'll put it out there. But I'll also remind you that the TEKS tell us we have to do this. So the people who wrote and enforced the TEKS and are responsible for testing our students have given us a lot of reason to talk about this and to try to make it relevant for our students. So when we look at the Shelby decision, the language of the Shelby decision, implicit in that is a reading of history that tells us that this is past history. This is settled, and Section 4 is no longer operable because the conditions that were on the ground in 1965 are no longer the conditions on the ground in 2013. There's a debate. There's actually an argument in what the Supreme Court justices write in their decisions about whether or not that's even remotely true. So that was the case in 2013. I can't imagine how many dozens, if not hundreds of bills the states have passed to curtail voting rights since then. I can't imagine how many hundreds of different voting systems localities have passed to make it either harder for members of minority groups to vote or to, through redistricting or whatever to dilute their voting power. So again, acknowledging that it's easier for me to do in the college classroom, at least for now, maybe not for much longer, than it is for you to do in history classrooms. I feel like I owe it to my students to help them understand the background of these debates that they're reading about in the newspaper. Hopefully they're reading the newspaper, seeing on TV, whatever the case is, seeing on YouTube, seeing on TikTok. I really feel like I have a responsibility to them to help them understand that and to keep them engaged in that and to realize what it took to get the Voting Rights Act in the first place. All of the blood that was shed in the first place to get the country to pay attention to the disfranchisement that African Americans faced in the South. And I just, you obviously know that I think that's important, that I feel passionately about it. But again, the TEKS tell us that we have to do that.
Right. Right. I think I just to add to what Todd has said, which is, I think, super helpful and inspiring. I think it's really important for us to use the primary documents, not just the primary documents of the Voting Rights Act itself, but around questions of voting, to help students to see that a lot of the same language and same debates are out there today. And we don't have to, if we have school boards that make it difficult to be explicit about contemporary politics, we don't have to bring that into the classroom. We can let students just see that. So I point out to students quite often how claims of voter fraud have been used over time. It's just factual that before the Civil Rights Act, and even after the Civil Rights Act, and before the Voting Rights Act of '65, and even after that, quite often local clerks, election clerks, and others would seek to discredit votes, saying they were fraudulent votes. And that language was used all the time. Have them see that, and then hope that they see the connection today. Maybe ask them if they're reading about stuff today without actually making that connection yourself. You can lay it out there for them to see. I think sometimes that's most effective, because then it actually doesn't seem like you have a quote agenda. Mm-hmm. You're exposing them to the history.
Exactly right.
I imagine, Todd, you do that all the time in the classroom, right?
Well, I'm probably guilty of sharing my agenda too, but I do appreciate that approach, and I shoot for that.
So, a question now from Robert Garcia. Great questions. Asks why Texas has been ground zero for voting rights cases. You mentioned that many of these cases are here. Why?
Yeah, I actually don't have a great answer for that. The white primary, the first time Texas really hits the map on this is the NAACP's assault on the white primary in the 1940s. So the Democratic Party was able to call itself a private organization that was not subject to the 15th Amendment. And so the Democratic Party could decide in the state of Texas who was eligible to vote in the Democratic primary and who wasn't. And so they used that legal argument to to keep African Americans out of the Democratic primary, which in the 1940s was the only one that mattered, right? That essentially mattered more than the vote in November. But Texas wasn't the only state that did that. It's just one that the NAACP sued successfully. And as the dissent and the Shelby case that we're going to look at points out, it was only one of three just from the state of Texas in which the NAACP had to sue for African Americans voting rights. So there definitely are cases from Louisiana and Alabama and the Carolinas and throughout the Deep South. But for whatever reason, the ones where the jurisprudence just really was clearest and most consequential, I guess, all happen to come from Texas. And maybe that's just something I've noticed since I've lived in Texas, and I go looking for things that have happened in Texas that I can throw in there to keep my Texas born and bred students interested in United States history. But I for whatever reason, I am convinced that these cases from Texas are the ones that ended up being the most consequential in the history of voting rights.
Yeah, and I think it does point out, Todd, that Texas has had problematic voting laws, right? It doesn't necessarily explain why it's Texas and not Georgia that gets more attention, but it does point to the repeated elements of problematic laws, which brings us to Brittany's question, which is about New York. And I think Brittany's spot on. I grew up in New York, so I know a little bit about New York voting rules. They aren't particularly fair either. New York is notorious for holding primaries on Thursday, in January, right? So no one knows it's even occurring, right?
Mm-hmm.
And for making it difficult for people to register to vote. So how do we think about this I think this is Brittany's question. How do we think about this in the context of New York, not just in terms of the South?
I'll answer that a couple of ways. One is just a general observation that people who have power tend to want to keep power. And so they come up with rules that help them keep power. And that's the case in Mississippi. It's also the case in New York and California. So that part is problematic. New York's voting systems did come under the purview of the Voting Rights Act with the renewal in 1970. So nationally, people did recognize that New York Democrats, especially, but the New York voting system in general, did discriminate against Spanish speakers and did make it prohibitively hard for them to vote. One of the best arguments that has come up, well, before 2013, when the Supreme Court struck down Section 4, one of the best arguments before that was, if preclearance is so great, the mechanism in Section 5, and if this calculation that determines where we have to send in federal registrars is so great, then why don't we just extend it to the whole country, right? Why pick on Sunflower County, Mississippi, and Lowndes County, Alabama, and South Texas, right? Just extend that to the whole country if that's so wonderful. And I actually was sympathetic to that. I would have liked to see the Voting Rights Act expanded that way, but it would have required the Justice Department to hire, I don't know, 50 times more, 100 times more, 1,000 times more civil rights lawyers just to enforce the Voting Rights Act, right? And so that would have been a massive federal overreach, according to some people, into local voting systems and statewide voting systems. And so I don't think that's something that conservatives ultimately would have supported, but I was very sympathetic to that argument that if it's good enough for Louisiana, if it's good enough for Mississippi, then it's good enough for Oregon and Idaho and everywhere else.
Right. And it's interesting, maybe this is not something you want to bring into your classrooms, but the current legislation that was filibustered would have gone much further than the Voting Rights Act, and it would have actually created more protections for voting in the states outside the South, which might in part explain the position that Joe Manchin and Kristen Sinema took on it, actually. You agree with that, Todd?
I do, and there are long arguments about how involved the federal government should be in voting because Even though the Constitution says that Congress has some power over this, the traditions in the United States are that we let states and localities make most of the most important decisions. But that obviously leaves minority groups in the lurch a lot of the time. So yeah, the John Lewis bill, I should have mentioned that when we looked at the picture of John Lewis. The John Lewis bill that has just been filibustered and seems to be on life support, if not all the way dead in the Congress right now, would have gone a long way towards nationalizing voting and nationalizing voter registration and voting itself.
Yep, absolutely. So this leads very well into Tammy's question. She makes the observation, correct, that in 2006, there was a Senate unanimous or near unanimous vote to renew the Voting Rights Act, including 16 of the current Republican members of the Senate who filibustered now the new legislation, voted for it. But her question actually takes us from there to the Supreme Court decision, the Shelby decision in 2013. How is it that views changed in those 7 years? Why is it that the Republican Party, because it wasn't just the Supreme Court justices, right? The Republican Party, or many elements of the party, did not want to see the voting rights and pre-clearance renewed, or wanted the court 7 years later to stop that?
Excellent question, and a really important question, and one that does not have any easy answers. But try and explain why Strom Thurmond would vote for the extension of the Voting Rights Act, and Trent Lott would vote for the extension of the Voting Rights Act. A cynic might suggest, or maybe do more strongly than suggesting, would suggest that the Republican Party simply wanted to get this issue off the table, right? That the historian Kevin Cruz has an op-ed out that came out shortly after the John Lewis bill failed, that now the Republican Party has stopped pretending to care about voting rights. Maybe that's right, maybe it's not, but I think it is clear that with the most recent renewal in 2006, that Republicans did make the decision, and the fact that President George W. Bush signed this as quickly as he did maybe backs this up, that they just wanted to get this issue off the table, right? They didn't want to be painted as the anti-voting rights party, and they may not have been completely on board with the calculus in Section 4. They certainly didn't like having to abide by Section 5, but that it just ultimately was not good for their political prospects if they'd allowed themselves to keep being painted as the anti-voting rights party.
Right, and so this was politically expedient for them. One might also argue that since then there has been more activism on the anti-voting rights side, and so people who might have had one change of heart have had to change of heart back. That's maybe a less cynical and more political point of view.
Yeah.